hello, and welcome to Crime and Court. My name is Heather, and this is another episode in the Canton Cover-Up series, Commonwealth versus Karen Reed, and the Commonwealth versus Aiden Turtleboy Carney. This is episode 67, titled Paul O'Keefe Files Civil Suit Against Reed in Two Bars. So basically, it is just what I said. We're going to be reading through the civil suit. Everyone is talking about this on social media, it seems, and I apologize that I did not get this to you guys last night. However, I had physical therapy, so I couldn't. So I apologize, but I kind of liked that it gave me some distance, and I was able to kind of digest it and uh, kind of give myself some time to process what I think about this civil suit. So, anyways, I'm gonna play a quick clip here from NBC 10 WJAR. They're reporting on this very same thing that we're going to be talking about. So let me boost that volume. Oh, it won't let me. Oh, there we go. Okay, here we go. So those two bars, as we know from the trial, are CF McCarthy's and the Waterfall Bar and Grill, and we'll get into that in a little bit. So, so one thing I have a real big issue with, and I want to go back over it maybe at some point in time, is the Yuri Buchanan testimony where he basically narrated security video from the bars, which a witness is not supposed to narrate the video while it's playing. So that's number one. And I don't know why it wasn't objected to, but they should have. The defense should have objected to that. And then number two, um, it just, he was obviously not quite truthful because the number of drinks that she was having or drinking, he it was insane the amount, and we weren't seeing it wasn't matching what was on the screen. He's like, "Oh, there's another drink. Oh, there's another drink." It's like, "What? What are you seeing that I'm not seeing?" So, definitely the amount of drinks that she was served is going to come into question for sure with this civil suit. The bars, CF McCarthy's and the Waterfall Bar and Grill, are going to have a motive now to prove that Karen Reed wasn't intoxicated. They didn't overserve her. They're going to have a motive to just score through the surveillance footage and try to determine the actual number of drinks that Karen had in order to prove that they did not overserve her. And we also know that it is possible to buy a drink and not drink it. It's also possible to buy a drink and give it to someone else. She may have bought rounds for people. She was very generous with her money. She made money, but she was very generous with it. She offered to pay for things all the time with the friends, and she seemed, she was very generous with the kids. She would buy them nice things. She would take them to Starbucks, which John didn't approve of or something. I don't know, whatever. I guess he didn't want the kids to get spoiled or something, but I mean, it's not bad to treat your kids to something every now and then. But anyways, um, and she had funds set up for the kids. She had like trust funds and things, so they would have been set for life if maybe not set for life, and maybe that's a little dramatic, but they would have had something to fall back on. Now I don't know if they still do or what's going on with those trusts, but yeah, she started trusts for the kids when she was dating John. That's how generous and selfless Karen Reed is. Anyways, moving on. So yeah, CF McCarthy's and the Waterfall are going to have to determine how many drinks she actually had. And they have now a vested interest in proving that Karen Reed was not intoxicated. We also know, and I'm rolling my eyes because we also know many, many people that were there testified that she did not appear intoxicated. John and her appeared to be having a good time. They appeared flirty and friendly with one another. They were friendly with everybody at the bar. Like there was nothing anybody had bad to say about these two, except when it came to like Jen McCabe and the mean girls of Canton, the mean moms of Canton, who all secretly had some crush and some possessive thing going on with John, even though Karen was the one that was dating him. So, yeah, no one said she was intoxicated. And the only bad things that were said were in snark or to try to dehumanize her. So, her defense, which is every defendant's right to say, I didn't do it, someone else did it. Obviously, if I didn't do it, someone else did it. So, it wasn't me. And my car didn't do it either. So, if that is true and she didn't do it, even if she did do it, she still has a right to say that somebody else did it. But and she'd probably likely be found guilty. But in this case, she didn't do it. So she has every right to defend herself and say, I didn't do it, someone else did. And that means pointing a finger at someone or someones that may have been involved. McAlbert, I'm talking to you. So she has every right to do that. So basically, in this lawsuit, they're saying that she created some kind of false conspiracy causing them distress. And that is, um, yeah, that's hurting them. And they should get money from that because she is defending herself by stating, I didn't do it. These other people are very likely to have done it. I mean, you can't make this stuff up. You can sue for anything. You can pretty much, um, don't know who I was listening to, but somebody was like, you can pretty much put anything in a civil suit. You can you can claim anything. It doesn't necessarily make it true. They still have to prove it, but you can claim anything. And when we read through this, we'll get to how it pretty much basically this lawsuit aligns with the Commonwealth's theory. So it almost seems as if they didn't watch the trial and they just were taking the Commonwealth's original theory blindly. Anyways, all right. Oh, sorry. All right. So that is the end of that. Let me swap over here. Oh, all right. So let's get to this civil suit. First off, I want to point out that this is um, several plaintiffs versus multiple defendants. So let's read those out. So we have Paul O'Keefe, who is the personal representative of the estate of John Joseph O'Keefe III. So I didn't know John was the third. Um, I thought he was just the second, but he is the third. Paul O'Keefe as himself, so Paul O'Keefe individually, John O'Keefe, the second, so that would be John's dad, so John Sr., and Margaret O'Keefe as grandparent and guardian of Kaylee Furbush, who is still a minor at this time. She is the niece of John. Noticeably, John's nephew Patrick is not on here. So it is interesting that they are potentially using Kaylee to bolster their complaint and get sympathy, perhaps, from maybe a jury because she's a minor. Anyways, that's just my 2 cents about that. All right, so versus CNC Hospitality doing business as CF McCarthy's, also GNS Hospitality doing business as CF McCarthy's. Then we've got the Waterfall Bar and Grill and Karen Reed. So let's get started. Parties/jurisdiction. The plaintiff, Paul O'Keefe, is the surviving brother of the late John J. O'Keefe III, otherwise known as JJ, John, or the decedent. And I don't want to call him JJ because I think that's weird. Grown man being called JJ. I don't know. Anyways, so, and I believe most people called him John or Johnny. So, I don't know. Anyways, all right. So, as is the duly appointed personal representative, Paul is the duly appointed representative of the estate of John Joseph O'Keefe III, who lost his life on or about January 29th, 2022. At all relevant times material hereto, the decedent resided in Canton, Norfolk County. At all relevant times material hereto, the plaintiff, Paul, resided in West Bridgewater, Plymouth County. Number 2, the plaintiff, John O'Keefe II, so this is the surviving father of John and Kristen. At all times material hereto, the plaintiff, John II, resided at One Meadows. No, he didn't. They're saying he resided at One Meadows Ave. That's where John lived with the kids. So that's not correct. That's a false statement. At all times relevant material here too. Maybe he lives there now, but I thought that him and Peggy were separated. I don't know. I didn't think that they were living together. All right, so now plaintiff Margaret O'Keefe, or Peggy, is the surviving mother of John and Kristen. Kristen is the sister who she passed away from glastia. What is it? It was a brain tumor, very aggressive form of brain cancer, and glastio something. I can't think of it. But and then shortly thereafter, their father passed away within like a month or so, and I believe he had a heart attack, but it might have been induced by certain substances. I'm not exactly sure on that. Um, Unconfirmed, but by a good source. Anyways, so both the parents passed away. Kristen is the sister, and that's when John took over guardianship of the kids. All right, so the plaintiff, Kaylee Furbush, or Kaylee, is the surviving niece of the late John J. O'Keefe III. At all relevant times material hereto, the plaintiff, Kaylee, was under the guardianship of John and resided in Canton. So she did reside at One Meadows with John. At relevant times, the defendant, CNC Hospitality, doing business as CF McCarthy's, is an independently owned restaurant with the usual place of business at 614 Washington Street in Canton. CF McCarthy's had a resident agent, Stephen B. Carey, 973. Yeah, we don't want to read his address. Sorry, buddy. All right, so CF McCarthy's, these are public docs, and this is how they came. So Not my responsibility to redact these things. C.F. McCarthy's presently appears to be operated by G&S Hospitality, whose date is whose date of organization was 4/24/2023. G&S Hospitality, doing business as C.F. McCarthy's, has the same location of business and same resident agent as C&C Hospitality, just basically saying they're the same, one and the same. The defendant, Waterfall Bar and Grill, doing business as Waterfall Bar and Grill. Okay, great. Uh, is a domestic corporation with a usual place of business in Canton. Waterfall has a registered agent, Gerard Meehan, located also in Canton. The defendant, Karen Reed, is an individual residing in Bristol County. The plaintiff repeats, realleges, and incorporates by reference as set forth hereto in their entirety all prior paragraphs of the complaint. The decedent, John, was the middle of three children in a tight-knit family. He was the middle? Was Kristen older? I guess. Okay, so John was a third-generation Boston police officer. After the tragic loss of John's sister Kristen and brother-in-law Steve, John took guardianship of his niece Kaylee and nephew Patrick, who were 6 and 3, respectively. Over the next 8 years, until his tragic passing, John raised and supported his niece and nephew. That's 8 years of being raised by someone. That's, you grow a very strong bond with that person, I am sure. And plus the fact that he took them in, just like, wow, the bond that the three of them probably had. All right. Anyway, so after the tragic loss of John, Margaret took ownership or guardianship. Sorry, guardianship. Oh, my brain. Guardianship / custody of her grandchildren, Kaylee and Patrick. At all relevant times on or before January 29th, 2022, John and the defendant Reed were in a dating relationship. I'm going to stop right there just a second to back up to say now that Peggy has guardianship of the kids. This is kind of a difficult subject for this family because originally, when both their parents passed away, John wanted to step up and take the kids, and Peggy wanted the kids, and I think Paul and Aaron also wanted the kids, and there were like civil suits between John and the mother, Peggy, going back and forth, going to court regarding the guardianship of the kids. Ultimately, John won. So, and there was some bad blood there. There is bad blood in the family still. I believe Peggy and John Sr. are separated, and I'm not sure if he's actually living with Peggy at the moment, but I do know that they are separated. They could still be living together and just like marriage-wise separated. I don't know, but it seems like they both have taken on the guardianship. Mostly the grandmother, though, has taken on the guardianship of the children. So, yeah, so definitely bad blood. I don't believe Peggy and Paul are speaking either. So it's curious that they're all on a lawsuit together. So, anyways, after I read that, at all relevant times on or before, John and defendant Reed were in a dating relationship. In the months, weeks, and days leading up to January 29th, 2022, John and defendant Reed's relationship was deteriorating. During such times, defendant Reed picked fights, experienced jealousy, and had delusions of unfaithfulness. So, what exactly is a delusion of unfaithfulness? I'm not sure what that means. And why this is even in here is totally irrelevant. I think it's just a slander Karen. Picking fights. Okay, did John not fight too? So it's not just Karen There were issues. It was a two-sided relationship. Am I wrong? Both people in the relationship, both people fought with one another. It wasn't just Karen fighting. And if she was experiencing jealousy, well, then John was perhaps maybe acting in ways that might have made her think that she was not secure in the relationship. So, you can't just sit there and say, well, she was jealous. So obviously, she was crazy and delusional and doing all these horrible things to John. No, it's a relationship. People have ups and downs. John probably picked fights too. John probably did things to make her jealous. Why was he hanging all over the Sullivan girl in Aruba when he should have been in the room with, first of all, I'll, I'll keep that to myself. Never mind. So he should have been in the room with Karen and the kids celebrating the new year instead of groping one of the Aruba sisters, in my opinion. And Karen thought so too. All right. So on or about January 28th, 2022, defendant Reed knew that her relationship with John, the grown man, his name was John, had run its course. So they're saying Karen knew that the relationship was over. On January 28th, 2022, at or about 8:51 p.m., plaintiff arrived at C.F. McCarthy's. C.F. McCarthy's was licensed to distribute, sell, or serve alcohol. On January 28th, 2022, at or about 8:58 p.m., C.F. McCarthy's served Reed an alcoholic beverage. Reed consumed said drink. That's it? She had one drink? All right. On the 28th, C.F. McCarthy's, through its agents, servants, or employers, served alcoholic beverages to defendant Reed at or about 9:13, 9:20, 9:33, and 9:57, 9:22, and 9:29. Reed consumed such drinks. Prove it. These are the things you gotta prove now. And prove that she drank them all. Prove that she didn't give them out. Prove that whatever. And this I have a really hard time with thinking that they can prove this because they didn't prove it to me on surveillance cam. All right, so C.F. McCarthy, through its agents, servants, or employees, served defendant Reed 7 alcoholic drinks between 8:58 p.m. and 10:29 p.m. on the 28th. During all relevant times at or before 10:29 p.m. on January 28th, defendant Reed showed signs of intoxication while at C.F. McCarthy's, which everyone else testified that she didn't. So there goes that. All right, so on January 28th, at or about 10:40, John and defendant Reed left C.F. McCarthy's. At or about 10:40, defendant Reed was allowed to carry her alcoholic drink out of C.F. McCarthy's. First of all, we didn't see this. So if they're saying that this happened, I didn't see her put a drink in her coat and I didn't see her pull one out of her coat. So I don't know about that. But someone else made a good point that she would have slammed that before she even walked into the other bar. If she was really trying to slam these drinks and get wasted and drive her cop boyfriend, who probably wouldn't have allowed her to get wasted and drive him since he called her for a designated driver. He made her come out there just so she could drive him home. That's pretty much how the text went that day. So he probably wouldn't have let her get wasted. She probably would have slammed it had she been there for the purpose of slamming her drinks and getting wasted and intending to drink drinks at every, 5-minute interval or whatever. She probably wouldn't have walked into the waterfall with it. But anyways. All right, so at or about 10:54, John and defendant entered Waterfall together. At all relevant times, Waterfall was licensed to distribute, sell, or serve alcohol. Defendant Reed walked into Waterfall carrying a drink from C.F. McCarthy's. Again, I didn't see her do that. At all relevant times on January 29th, while at Waterfall, defendant Reed shows signs of intoxication. Again, prove it. Everyone that testified said she did not show any signs of intoxication, and nobody could verify what she was drinking. It was a clear liquid. You know what else is clear? Water. Water is clear too. So, water, tonic. She might have just wanted some seltzer water, which would have looked like a drink potentially. I have at many times gone into bars and just ordered a seltzer water with a lime, and there's nothing wrong with that. It kind of looks like you're drinking. You could say put it in a glass, like a cocktail glass, so not like a regular glass that you serve Coke in or something to the restaurant portion. Um, so it could be water, could be tonic, could be anything. Doesn't have to be alcohol. Anyways, all right. So on January 29th at approximately 12:10 a.m., defendant Reed left Waterfall. Approximately 12:11 a.m., John left the Waterfall. So 1 minute later, at all relevant times on January 29th between 12:11 and 12:36, defendant Reed was under the influence of alcohol and unable to drive a motor vehicle safely. We don't know that. At all relevant times on the 29th, defendant Reed drove John to the residence of 34 Fairview Road in Canton, Norfolk County, Massachusetts. That we don't deny. Defendant Reed and John had been in an argument the night of January 28th into the morning of the 29th. We don't know that either. She said that they argued in the morning. They looked very friendly and romantic and flirty and affectionate with one another at the bar. And other people, Mrs. Kolakithis, the Greek couple that was there, had said to her husband, I wish you were more like them. Like, I wish you would be more affectionate like John is with Karen. So, what argument? I think maybe they were over it from the morning. Or at least, put on a good show of it. And if she was really ragingly crazy and wanted to end his life, I doubt she would have been able to put on that act. All right, so after JJ got out of defendant Reed's vehicle in front of 34 Fairview Road on January 29th, Reed drove her SUV and hit John. At all relevant times on January 29th, defendant Reed drove her SUV in a state of intoxication. Again, prove it. As a result of Reed's SUV hitting JJ on January 29th, JJ was knocked down onto the ground in front of 34 Fairview Road, suffered serious injury, and lost his life. After hitting John with her SUV, defendant Reed fled the scene and returned to John's residence at One Meadows Ave. At all relevant times, defendant Reed knew it was snowing, knew there was an impending blizzard, and knew or should have known that leaving John outside in the blizzard would likely result in serious injury or loss of life. At all relevant times, when defendant Reed drove her SUV and hit John, defendant Reed failed to use any care to avoid creating an unreasonable risk of harm to the public and John. She voluntarily took an obvious risk under the circumstances, knew or should have known the loss of life or serious injury was reasonably predictable, but everyone else in that group of friends was also drinking and driving. Not everyone, but the majority of the people that, testified at trial were also drinking and driving. So let's not forget that. And probably were way more wasted if Karen was even wasted, but they were wasted, and she probably was nursing some gin and tonics and water in between or something, who knows? All right, so voluntarily took a risk, persisted in a clearly negligent course of conduct over a noticeably period of time, was impatient with reasonable precautions, was impatient? What? What does impatience have to do with anything? Was deliberately inattentive to the predictable hazards of her actions and or was deliberately inattentive where there was a risk of great and immediate danger. So it almost seems like They're claiming that it was an accident, but that's not, they have to have it be an accident, like she accidentally or didn't intend to hit him, and it was due to the alcohol in order to get payouts from the bars. So that's what they need the bars to eventually conclude. But the bars are going to do their own investigating and do their own depositions on McAlberts and Karen Reed and all. Well, Karen has the right to remain silent until her criminal proceedings are over. But they will depose people for sure. The insurance companies of these bars are definitely going to depose people. They're going to get way more discovery than you can in a criminal case. And all the things that, Judge Bev tied the defense's hands at, they have the opportunity to possibly, potentially obtain to help their case. So this is not good for the McAlberts, this lawsuit. It's probably not good for the O'Keefes either because there's no proof that Karen hit them. The ARCA guys might even come forward and do, more to prove that now because there's even more at risk and more people's lives that are being affected by this. These poor business owners who they just are having a normal night of drinking, nothing's wrong, and then these, mm, I, I'm not gonna say what I think of the O'Keefes. People don't like that, but they can be crappy people and also have had a tragedy happen to them. A lot of people can be crappy people and still have had bad things happen. That doesn't make them less crappy. So. All right, so and deliberately inattentive where there was risk and great immediate danger. At all relevant times when defendant Reed drove her SUV and hit John, defendant was reckless when she intended the reckless conduct, and so now she's intending it. She's intending to be reckless, and that resulted in John's injuries. Her conduct made it highly likely that someone, namely John, would suffer serious injury or lose his life. She knew or had reason to know of the risk of grave injury or loss of life to John, or said risk would have been obvious to a reasonable person, and she intentionally or unreasonably disregarded that risk. John's injuries or loss of life resulted from defendant Reed's decision to engage in the conduct referenced above in the sentences above. On January 29th at approximately 4:30 a.m., defendant Reed knew that she hit John. Okay, so now you have to prove that she knew she hit John at 4:30 a.m. You have to prove that. All these claims that they're saying in here, you got to prove them now. So this does not help the O'Keefe's family because Karen Reed is factually innocent and they're coming after a factually innocent woman and some establishments that serve food and liquor and basically just to make a quick buck. Because the insurance companies for the bars might just say, you know what, it's cheaper to settle, so let's do that. Or they might litigate it and do their own investigations and fight this because that's their name on the line, that's their reputation, which I have a feeling might happen. So, anyways, so now they're saying that she knew she hit John with her SUV at 4:30 a.m. Nonetheless, she woke up John's 14-year-old niece, Kaylee, and talked about John's loss of life, talked about hitting John with her SUV, and otherwise involved Kaylee in her frantic calls about John's loss of life. So, no, she woke Kaylee up because Karen was anxious. She was nervous that something had happened to John. A concerned girlfriend would be that way, would she not? A concerned girlfriend would be frantic looking for her boyfriend. And she woke up Kaylee so that she could get John McCabe's number. She didn't have it. So this was in an effort to find John, to look for John, something that the McAlberts never really did. Although they claim they did, but they they had blinders on for some reason, and while they were looking for John in the car, they couldn't see John in the snow. A 6 foot, 200 something pound man in the snow. All right, at all relevant times on or about January 29th, defendant knew that Kaylee was a vulnerable minor who already lost her parents tragically and depended on her custodial uncle John, who became her surrogate parent. At or about 5:07 a.m. on the 29th, defendant Reed left Meadows. That's when she actually damaged her taillight. Between 5:18 and 5:35 a.m., defendant Reed knew John was seriously injured, buried in the snow, and laying on the ground in front of 34 Fairview Road, where defendant Reed left John to lose his life hours later. On the 29th, defendant Reed admitted repeatedly that she hit John. At or about 6:03 a.m., defendant Reed arrived at 34 Fairview in Canton and immediately observed John laying on the ground, buried in the snow, where she had left him to die. No, he was not buried in the snow. And first responders even said, no, he wasn't buried in the snow. He had some like crystals on his face from the snow landing on him, but that was it, I think. I mean, like his body was warm enough to melt snow. It wasn't covering him. I mean, his body was cold, but it still was, 80 some, I think like 85 degrees or something like that, which is hypothermia. It's a severe stage of hypothermia, but you're still warm enough to melt snow. All right, so at relevant times, John suffered trauma injuries before becoming hypothermic. At or about 7:50, John was pronounced no longer alive at the hospital. At relevant times after 7:50 a.m. on January 29th, defendant Reed went to the grieving house of John, feigned comfort to John's family. Okay, so now you got to prove that she was faking comfort to them, and used the opportunity, amongst other things, to remove the offending weapon, which is her vehicle, they're saying, and to destroy relevant evidence, which that has also been debunked. They're saying, so first of all, like, she's not supposed to take her car. Like, why wouldn't you take your car if you're leaving? I guess they didn't want her to leave they wanted her to leave her car there, even though would have been weird. And also they think that she destroyed ring camera evidence, which the kids testified to the fact that neither they nor Karen Reed had access to any of the ring camera footage. It was on John's phone. That's it. And if it was on a computer upstairs, we don't even know because nobody had access to it. So there's that. All right, so at all times after 7:50, grieving family, opportunity to, amongst other things, remove her vehicle and destroy relevant evidence. Okay. So on January 29th, defendant Reed's BLOOD was drawn, reading of 93 milligrams per whatever that means, DL. Hold on, it's going to get loud for a second. I have no idea why my dogs are all running down the stairs. No one's here, but anywho, all right. So they're saying that her blood was drawn, a serum conversion and retrograde extrapolation was done of the results of defendant Reed's BLOOD, which the results were that it was anywhere between 0.13% to 0.29%, which is a huge variation. And that was they're saying that's what it was around the time that she drove and hit him. However, that was also proven in cross-examination that it's a faulty um, um, equation, like faulty equations that were used because you have to determine the actual time of her last drink in order to do it. So, and plus, why is there such a wide variation? That seems ridiculous to me. So, anyways, and her blood was also drawn not by, they needed a warrant if they were going to use it for that. And there was no warrant. It was just the hospital sectioning her. I think they made some bogus explanation up to get her to the hospital to draw her blood because of this fact. They wanted her blood. And so I don't even trust the results. Um, they're not to be trusted, and they weren't done in the proper protocol. The blood draw wasn't done in the proper way in which if there was a warrant, it would be done. So we can't trust whatever that BAC is. It's just not trustworthy. It's not credible. So Reed's BAC of 13.13% to 0.29% all exceeds the legal limit to drive a motor vehicle in Massachusetts. At relevant times, on or about, the 29th, defendant Reed drove her SUV while under the influence and hit John with her SUV. As a direct and proximate cause of Reed's drunk driving, John sustained serious injuries of body and mind, conscious pain and suffering, fear of impending loss of life, lost earnings, medical, funeral, and burial expenses, and loss of life. So they're going to have to prove that too when the medical examiners and anyone that had evaluated his autopsy, the experts, they all said that he would have been unconscious with the amount of head trauma that he had. So he wouldn't have been able to crawl. He wouldn't have been able to move. So that is why Trooper Paul said he flew 30 feet from point of impact, which is not possible hitting his arm. So yeah, it's just very odd. I think if there was any fear of impending loss of life, it was in that basement as he had Brian Albert, Brian Higgins, Chloe the dog, and Colin Albert allegedly coming at him. I think that was his fear, conscious pain and suffering, injuries to his body and mind. Those should be directed towards the actual culprits. Notwithstanding her Fifth Amendment right not to speak, defendant Reed chose to speak publicly. She knowingly and deliberately changed her story. No, she didn't. And fabricated a conspiracy. Again, she's not allowed to defend herself and say someone else did it. She publicly communicated this false narrative, thereby frustrating justice for JJ. I'll say it there because that's what they call it, justice for JJ. But those are the blue shirt people who have no desire for justice. They just want Turtle Boy and or Karen Reed to go down. Such a false narrative caused the plaintiffs aggravated emotional distress. So the narrative from the defense of the McAlberts did this caused the O'Keefe family emotional distress. Why? Why? Why does Karen Reed putting the blame on the people that actually did it, allegedly, why does that cause them emotional distress? Wouldn't they want the actual people who did it to be behind bars and not just put Karen away just because? So the plaintiff lists above bring this complaint seeking full and complete justice for JJ. Count 1. The estate of John O'Keefe versus C.F. McCarthy's in the wrongful death suit in whatever statute that is. All right. So the estate repeats, realleges, and incorporates by reference as set forth hereto in their entirety prior paragraphs of the complaint. So we're just reaffirming everything above. Defendant C.F. McCarthy negligently served alcohol to an intoxicated person, namely Defendant Reed. Defendant knew or should have known that Defendant Reed was intoxicated at relevant times of service on the 28th. Okay. Defendant C.F. McCarthy's violated Massachusetts dram shop laws, company safety policies, and was otherwise negligent for numerous reasons, including but not limited to. So they have to actually prove. So dram shop laws apply to, people over serving in bars, and bars are supposed to be trained to acknowledge this and make sure that they don't do that. because they don't want to be held liable. So you're going to have to prove now for sure that they overserved Karen Reed. And again, you have to prove that every single drink that she bought, she drank and it didn't go to waste or she didn't give it to somebody or whatever the case may be. So anyways, they are negligent because of these reasons. Its decision not to hire competent employees, staff, bartender, servers, its decision not to provide adequate personnel to work at CF McCarthy's at relevant times, not to provide adequate safety training to its employees, staff, bartender, servers, to violate its safety training to retain unfit employees, its choice not to supervise adequately its employees. The defendant, C.F. McCarthy's, acted not only with indifference to its legal duty not to serve intoxicated patrons, but also with utter forgetfulness of said duty. So they just forgot their duty altogether there. The defendant, C.F. McCarthy, their duty to not overserve people. The defendant, C.F. McCarthy's, acted with gross negligence. C.F. McCarthy's acted with willful, wanton, and reckless disregard for the safety of others. That you got to prove. And when it served an intoxicated defendant. C.F. McCarthy deliberately ignored the applicable risk and or voluntarily incurred the obvious risk of serving defendant Reed when she was already intoxicated. C.F. McCarthy's persisted in serving Reed alcohol well after it knew the defendant Reed was visibly intoxicated. No one saw her visibly intoxicated. So, again, prove it. Defendant C.F. McCarthy's continued to serve defendant Reed alcohol at relevant times when Reed was already intoxicated. As a direct and proximate result of defendant C.F. McCarthy's negligence, gross negligence, and her willful wanton disregard for safety, John sustained serious injuries of body and mind, serious pain and suffering, fear of impending loss of life, lost earnings, medical, funeral, and burial expenses, and loss of life. As a direct and proximate result of defendant C.F. McCarthy's negligence, and all that other stuff, John's next of kin suffered as well. John's next of kin, so Kaylee, but Patrick isn't listed, so that's weird. So John's next of kin are entitled to John's lost value resulting from his wrongful loss of life. Such damages include, but are not limited to, reasonably expected society, companionship, comfort, guidance, counsel, net income, services, assistance, protection, care, and advice to each of next of kin. So even though Patrick's not in here, they're saying he is there. I mean, they're counting Kaylee and Patrick as two. Wherefore, the estate of John Joseph O'Keefe III demands judgment against the defendant C.F. McCarthy's on count 1, plus counts compensatory and punitive damages. I don't know why that was so hard for me to get out. Lost value of next of kin and any other relief this court deems appropriate. Count 2, the estate of John versus the waterfall. The estate repeats and realleges everything above. The waterfall was negligent when it served alcohol to an intoxicated person, namely Defendant Reed. Defendant Waterfall knew or should have known that Defendant Reed was intoxicated at all relevant times on the 28th. Defendant Waterfall violated the Massachusetts dram shop laws, same thing about over serving people. And it's negligent in its decision, same things, not to hire, not to provide adequate personnel, violating safety training. The defendant, Waterfall, acted not only with indifference to its legal duty not to serve intoxicated patrons, but also with utter forgetfulness of said duty. Again, these bars are not going to be happy that they're getting involved in this, I have a feeling. And they might just fight this just to clear their names. The defendant Waterfall acted with gross negligence. The defendant Waterfall acted with willful, wanton, and reckless disregard. Oh, somebody said, I think this was Peter, lawyer said on his stream that if you say something in a civil suit, it's not considered defamation. So you can file a civil suit against somebody, basically defaming the crap out of them, and it's not considered defamation because it's in a civil suit. So I'm not saying that anybody should do that. I'm just saying like that's bogus. I think it should be part of defamation because there should be, I mean, I guess there's limits, but whatever. Still crazy to me. All right, so the defendant Waterfall deliberately ignored the applicable risk and voluntarily incurred obvious risk. Defendant Waterfall continued to serve defendant Reed alcohol at times relevant when Reed was already intoxicated as a direct and proximate result of defendant Reed's negligence. All that same stuff. John sustained serious injuries of body, mind, conscious pain and suffering, etc. As a direct and proximate result, the next of kin also suffered same thing. They lost value, resulting in his wrongful loss of life. Wherefore, the estate of John O'Keefe III demands judgment against the defendant Waterfall on count 2, plus costs, compensatory and punitive damages, lost value to next of kin, and any other relief this court deems appropriate. Count 3 against Karen Reed. Plaintiff repeats, realleges, and incorporates all of the above, basically. On the date of the crash, and at all relevant times, defendant Reed owed John and the public at large a duty not to drive drunk. What about everybody else that drove drunk home that day? To drive her vehicle safely and or with care, or with due care. At the date of the crash and at all relevant times, defendant Reed owed John and the public at large a duty to pay attention to the roadway. On January 29th, and at all relevant times, defendant Reed breached her duty or duties of care to John by driving drunk, driving in an unsafe manner, and or without due care. As a result and or approximate cause of defendant Reed's negligence, gross negligence, and or willful, wanton, and reckless disregard for safety, John sustained serious injuries of body and mind and all that other stuff, etc. As a result and as a direct and proximate result, the defendant's negligence, gross negligence, and or willful, wanton disregard for safety, John's next of kin suffered. Next of kin are entitled to the lost value resulting from his wrongful loss of life. Such damages include, but are not limited to, and all those same things again. Count 4. Okay, so now Margaret O'Keefe, Peggy, John's mother, versus C.F. McCarthy's. I'm sure it's going to say all the same things. So, at all relevant times, Margaret was the mother of John. Margaret O'Keefe learned of John's admission at the hospital immediately and came upon John's body at the hospital shortly thereafter. C.F. McCarthy's negligence caused the loss of Peggy's son, John. Margaret suffered severe and profound emotional injuries manifesting in physical symptoms as the result of observing John at the hospital and witnessing the consequences of C.F. McCarthy's negligence. I don't think this has a whole lot of standing, but still, they have to say, well, she suffered physical symptoms like she can't sleep at night or she has visions at night and night terrors or whatever because of seeing her son in that condition. I'm just guessing. I don't know. That was a speculation on my part. I was just giving an example of what a manifested physical symptom might be from seeing him. So, but again, prove it. Are there medical records? Does she have in her doctor's notes that she's having panic attacks or whatever? Margaret's emotional injuries, severe physical pain, anguish, emotional distress, and other harm were directly and or approximately caused by defendant C.F. McCarthy. A reasonable person in the same position as Margaret at the same time of John's loss of life would have suffered severe and profound emotional distress. Wherefore, plaintiff demands judgment against the defendant, C.F. McCarthy, on count 4 plus interest, costs, and other relief. So, not just what we're asking, but more. Count 5 is John O'Keefe. So, this must be Senior? John O'Keefe Senior versus McCarthy. Yeah, so he's the father. Same things, I'm sure, is going to say as the mother, wherefore plaintiff demands judgment against the defendant, C.F. McCarthy, on count 4, or sorry, 5. Count 6, Paul O'Keefe versus C.F. McCarthy. Same old, at all relevant times. Paul O'Keefe was the brother of John. Paul O'Keefe learned of John's admission at the hospital and immediately came. So, again, this is just repeating the same thing. Paul suffered severe and profound emotional injuries manifesting in physical symptoms. Paul's emotional injuries, severe physical pain, anguish, emotional distress, and other harm were directly related to C.F. McCarthy's negligence. Therefore, grant this motion. All right, count count 7, 6, 7. What are we on? 7. Sorry. I can't do Roman numerals that fast. So Margaret O'Keefe versus the Waterfall now, saying the same things. John O'Keefe Sr. versus the Waterfall, saying the same things. Paul O'Keefe versus Waterfall, same things. Margaret versus Karen Reed, same exact things. Same exact things as the bars. So same, yeah, nothing changed from the verbiage. Then you've got count 11, which is John O'Keefe Sr. versus Karen Reed, which I am kind of torn on. I thought John O'Keefe Sr. liked Karen, was on Karen's side. Maybe he's been bullied or pressured by his family to be in on this lawsuit. I'm not really sure, but I'm kind of surprised to see him on here just because I thought that he was more on Karen's side, and he actually was a witness on the defense's list. But obviously, the prosecution didn't call him, but he was a witness for the defense, so he could have very easily been called and said some things that might have been very complimentary to Karen, might have been, I'm not really sure, but now, it just confuses me that he's in on this. And I also think that there's a rift between the family members because of this case and because of how they feel about who did it potentially. Anyway, so John Sr. versus Karen, same things. Paul versus Karen, negligent and or reckless infliction was the count. Sorry. Yeah. So that's the same for all of the individuals. And now there's a Kaylee Furbush versus Karen. At all relevant times, Kaylee was the niece of John. John was her guardian since her parents passed away. Kaylee learned of John's loss of life or injury when defendant Reed woke Kaylee up at approximately 4:30 a.m. on January 29th. Defendant Reed knew Kaylee was vulnerable, having already lost her parents at age 6. Nevertheless, in Kaylee's presence, defendant spoke on speakerphone to various people between 4:30 and 5 a.m. on January 29th. At all relevant times on January 29th, Kaylee heard defendant say, "John never came home. Maybe I did something. Maybe a snowplow hit him. Maybe I hit him. Maybe I hit him. We were in an argument. Maybe he got hit by a snowplow." We're not sure when this was said, if this was even said, because we do know that law enforcement never interviewed either the niece nor the nephew until months later, after the family, the McAlberts, everyone had a chance to potentially influence their thoughts influence their experiences and paint a bad picture of Karen, taint their experiences with Karen. I mean, it's very, very possible that the family just turned on Karen and the kids picked up on that. Not even meaning to, but they did, and now they're in it because the family made them testify and they overheard whatever. So I don't really trust a whole lot of what was what we are told of what was said in the mornings and what happened in that time frame. I don't believe a lot of it because a lot of it is coming from not reliable sources. All right, moving on. So, as a result of the conversation defendant Reed had in her presence, Kaylee perceived the injuries caused to her guardian, Uncle John, and perceived the injury producing event. What? Because she heard Karen freaking out about the fact that John didn't come home. But it was true. It's not like she was making something up. So if Karen was reacting to the fact that John hadn't come home and Karen was, panicking and upset, how can you blame her? I don't understand. Like, they're trying to blame her for being upset to make Kaylee upset when in all reality, there was reason to be upset. There was reason to be anxious at the moment. So it's not like she did this on purpose to like incite anxiety and fear in this child. But moving on. At or about 5 a.m., after waking Kaylee up and informing her that something happened to John, defendant Reed left Kaylee home alone. Defendant Reed intentionally okay, she's 14. She can be home alone. And it was probably more responsible to leave Kaylee at home so that, one, if John did come home, Kaylee could, tell John, hey, get a hold of Karen, or let me tell Karen, or whatever. And also, Karen, the roads were bad. It was starting to snow at that point, not, 8 inches of snow at that point. So she didn't want to unnecessarily bring Kaylee out on dangerous roads, I'm sure, too. So that was probably a factor in her decision to leave Kaylee home. So I don't know what the leaving her home has anything to do with anything. So defendant Reed intentionally and or recklessly inflicted severe emotional distress when she woke up Kaylee and informed her that she hit her uncle and that a snowplow hit her uncle. So again, I don't know if that is actually a fact. But they think it is. So now you got to prove it. Defendant Reed either intended to inflict emotional distress in Kaylee or knew that she should have known that emotional distress was likely to result from defendant Reed's conduct. Defendant Reed's conduct was extreme and outrageous, beyond the bounds of decency, and was utterly intolerable, so they're saying. Then, after John was declared deceased, defendant Reed came to the family house and feigned concern. You have to now prove that she feigned concern. Dude, she's hurting too. Her boyfriend is no longer alive. She is in a state of shock, grief, panic, whatever you might be feeling in those moments, that's what she's going through. And she's probably feeling numb at that point because it's been hours. She's been sitting at the hospital. They've been thinking that she's going to take her own life, which I don't believe actually was said. I think that was something made up to get her into the hospital to get that blood draw. So there's so many flaws with this lawsuit. As you can see, we're pointing out many, and I have only just begun. I mean, so many other people have picked apart a lot of this stuff too. So it's good that we have a lot of eyes on this because I don't think this is going very far. All right, so the emotional distress suffered by Kaylee was severe and of a nature that no reasonable person should be expected to endure. Defendant's extreme and outrageous conduct caused Kaylee aggravated emotional distress. Kaylee also suffered severe and profound emotional injuries as a result of perceiving John and John's loss of life and or the injuries producing event. What? Kaylee also suffered severe and profound emotional injuries as the result of perceiving John's loss of life and or injurious producing event. She didn't see the event take place, the consequences of Reed's negligence. She didn't see the event happen. I'm very confused on that one. Okay. The defendant Reed outrageously created a false narrative. Prove it's false. Prove now that it's a false narrative. Prove that the McAlberts didn't have John O'Keefe in that basement, likely the basement, allegedly, and beat him to a bloody pulp. 'Cause that's what I think happened. All right, so Kaylee's injuries, emotional injuries, severe physical pain, anguish, emotional distress, and other harm were directly and or approximately caused by defendant Reed's actions. A reasonable person in the same position as Kaylee Furbush at relevant times, including the time of John's loss of life, would have suffered severe and profound emotional distress. Wherefore, plaintiff demands judgment against the defendant Karen Reed on count whatever we're at 13 plus interest, costs, and other relief or damages. And that is the end of that. That's the civil suit for damages that the O'Keefe family is seeking for what they claim is the wrongful loss of life of John O'Keefe. And at this point, there has been no proof whatsoever that Karen committed any kind of crime, let alone, was drinking and driving. I still have yet to believe there's no proof yet that she did anything like that. I mean, did she have a few drinks at a bar? Sure, maybe, but we don't know, and it was all clear. Could have been water. She wasn't having the greatest health day that day. So with all of her MS and all of the things that she deals with, so she might not have been drinking alcohol. We don't know. We don't know. And that's the point. And here we are suing the pants out of her, or trying to, because she's got money and the bars have insurance money. And that is the crux of this. Paul and the O'Keefes just want some kind of financial something. Even though John's life insurance, his house, his car, and all that weren't enough. His house, his car, his life insurance. Now they want to go after his former girlfriend, his girlfriend at the time of his passing, just because. There's no way they can possibly believe that she did it. And if they do believe that, they're pretty effing stupid. Sorry, but they are. Because they sat through that trial. And can you stop? The dog's being annoying. She wants to go OUT. So yeah, they sat through that entire trial, and if they came away with that still thinking that Karen did something that night to cause his loss of life, then there's no hope for them. And hopefully this lawsuit getting tossed immediately by these folks, coming back at the O'Keefes. What about Paul O'Keefe's accident where he caused severe injuries to a man when he was driving drunk in the middle of the day at 4:30 in the afternoon from a golfing event? He got into a horrible accident. That guy, I don't know if that guy ever came at Paul, but he should now if he hasn't. Just for the heck of it. I also want to point out the fact that Paul O'Keefe, the other thing. So they got John's house, they got John's car, they got John's life insurance, and there was also a GoFundMe page that was raising money for the Furbush kids, and that was over 300 grand, and that all went to Paul. We don't know what happened to it. It didn't go to the kids, but we believe Paul may have taken over that money, and we don't know. So just something to put out there. I'm not saying nothing. These are kind of speculative, but we do kind of know some of the things. I mean, we know he got into an accident. We know about the GoFundMe. We just don't know where the money went. So Paul was the fundraiser, the organizer. So I don't know. We shall see what comes of this. What do you guys think of this civil suit? What do you think of Paul and the O'Keefe family, period? I mean, I have not been very shy about how I feel about the O'Keefes. I don't think they're great people. I think John was a decent person. He had problems though. He was flawed just like everybody else. I think John was a major alcoholic for the blood alcohol level that he had, which we can pretty much determine is accurate because that was why would they mess with that? Number one, number two, that was what his alcohol level was at the time of his loss of life because nothing would have changed that. He wouldn't have had time to lose that, um, to lose the level of the saturation of alcohol to blood, whatever it is. I don't know what I'm saying. I'm not a sciencey person. I'm not a doctor. But anyways, so yeah. So I'll leave you guys with that. Think about just the fact that, just because it's in a court filing doesn't necessarily make it so. These things, it's probably going to go to trial. At least with Karen, if it ever even gets to that, this might get tossed way before because they're probably going to stay. The bars might continue it. They might just say, we want to deal with this after the criminal complaint is dealt with. So I don't know. It really could go a bunch of different ways, but hopefully we get some real answers because discovery is going to come, depositions are going to come. The Alberts are not going to be able to keep their story straight for a third, fourth, fifth, however many times. So ultimately, this lawsuit is good for Karen. It's good for Karen. It's really bad for the McAlberts. It's probably not going to go very far for the O'Keefes. That's my take. What do you guys think? Please let me know in the comments below, and I will see you guys in the next one. Take care. Bye, guys.